Hello, everyone. My name is Art Carter. I'm CEO of the California Regional Multiple Listing Service. And we'd like to give you a little bit of an update of what we're seeing out of the lawsuits and the results of those lawsuits within the legal framework of what it takes to operate a multiple listing service. I have Ed Zorn, who is Vice President and General Counsel of CRMLS here with me. And we're going to go through some basic elements of the lawsuits, what has been going on with those lawsuits, and really kind of the outcomes and what effects they might have on our brokers and our agents and their day-to-day business. Ed, do you want to give a little bit of a background of the lawsuits for it always amazes me in going out and speaking with people. I always ask the question of how many people have heard about the lawsuits. And at this point, it's still a 50-50 game of people who have actually heard of them. So why don't you give people an idea of what it is that has been occurring and what those lawsuits are about?
So the lawsuits started about almost 5 years ago. And the first lawsuit, known as Sitzer, it also was renamed as Burnett versus the National Association of Realtors. And they also named Keller Williams, Berkshire Hathaway Home Services, as well as Anywhere and Remax as far as the corporate entities. And those kind of grouped together called the corporate defendants. And it's a class action lawsuit with the plaintiff being a group of sellers. And they basically argue that the system that has been in place as a result of NAR mandatory multiple listing service rules that MLSs are required to follow, in conjunction with the major brokerage houses and corporate defendants and brokers, have conspired together and kind of come up with an understanding or a program that artificially and in violation of antitrust laws elevates or keeps high kind of a standardized commission structure. And it's precisely what they argue is that in our system of listing brokers offering compensation in a multiple listing service, they argue that when the listing broker goes into the seller's home and negotiates the terms of the listing agreement, they talk about the need for the seller to have to pay the buyer's agent. And then that should be included in their listing agreement. It is shared on the multiple listing service. And in this first trial that happened, they put forth some evidence that there were training materials where agents were taught to tell sellers that if you didn't offer a certain level or a certain amount of compensation to the buyer side, that buyer agents wouldn't bring their buyers to your home. So it was important to make sure you hit a certain number, or you may receive some situation where people don't look at your house. And so that was the basis of their claim. And that trial went forward for a couple of weeks in Missouri, and we've now had a verdict on that.
So Ed, let's talk a little bit about the verdict. The jury came back in about an hour and a half of deliberation with almost $1.8 billion claim. They did certify that claim against the defendants. There are obviously, a lot of things occurred leading up to the trial. Anywhere and Remax did settle prior to the trial. So the defendants going forward were NAR, Berkshire Hathaway, and Keller Williams. So let's talk about that. From an antitrust standpoint, those damages can be trebled. So you're looking at a situation where the remaining defendants are potentially on the hook for almost $5.4 billion. Talk a little bit about, that process and what's going to occur, post, we're about a week in to that decision tree process, but walk everybody through what's going to happen, with potentially an appeal and potentially an injunction that may or may not be on the judge's docket.
Sure. So a couple of things that we know in watching the trial happen, and that is that the plaintiffs got the entire first week to make their case. They used quite a bit of evidence from the defendants. Again, their training materials, rules, things that were developed by the defense, NAR and the corporate defendants. And then they also put forth testimony from some expert economists, as well as their own clients, the plaintiffs, and the experience that they had in moving through the home sale process. That was then followed by a little more than a week of NAR and the corporate defendants putting up their case, where they were able to articulate and make some arguments and establish some facts that the defendants thought would show that there was no agreement and no conspiracy coming together or understanding on the stabilizing of these commission rates. The jury was out for such a short period of time that what that tells us as trial lawyers is that they really did not buy into or consider as very probative the arguments being made by the defendants. They basically bought the arguments made by the plaintiffs all the way and didn't really probably find a lot of credibility in what the defendants were trying to argue when the jury weighed the facts. And that we know this also because they came back with a verdict that was almost exactly what the plaintiff was asking for. So it went very quick, which tells you there was not a lot of debate or differences of opinions between the jurors who heard the evidence. And they came back at a number that very quickly established that they agreed with the plaintiff and they think the plaintiff should get everything that they were asking for from a money standpoint. So now the jury's job is finished, and it's the jury's job to look and weigh the evidence to determine what the facts are. Then the judge gives the jury instructions, and he tells the jury how they have to apply the law to the facts that they determined. And that's what then creates that verdict. So some things that are going to be happening now in the next stages. One of the other things that the plaintiff asked for was an injunction. And an injunction is a court order where the court either tells somebody in the defendants to not do something, or in the alternative, it can tell them to do something on the affirmative side. The judge kind of sent everybody home after a couple of weeks. You know, these trials are very exhausting. They take a lot out of you as attorneys and as principals. And so I would expect that in the next coming few weeks that there'll be some additional hearings that will take place. One of those will be on an injunction, and another one will be a bond hearing to deal with the appeal. So let's talk a little bit about the injunction first. An injunction can go a couple different ways. One thing a judge could do is tell NAR that they are no longer allowed to have a rule in their MLS handbook that requires compensation. In all honesty, the way the world has worked, forever, you could put in $1 or 1 penny, depending on your MLS system, which is the equivalent of nothing. Right. So the reality from a practical standpoint is that there really has never been a mandatory requirement or a mandatory number that ever has had to go into the MLS. But more recently, NAR has authorized us as MLSs, and CMLS has complied with this in that you can put 0 in. 0 is a valid number that our computer and the MLS system will accept as an offer of compensation. So the idea here that the judge would issue an injunction ordering NAR to remove their mandatory rule, kind of honestly, from a practical standpoint, will do nothing. On the other side, we could have the judge issue an affirmative rule. And an affirmative rule would be asking NAR, or I should say requiring NAR, to issue a rule that all NAR MLSs must have a rule that says you are not allowed to have any compensation in the multiple listing service. There can be no offer, unilateral offer of compensation from anyone, that being the listing broker or the seller. They could do that. The judge could also split the difference and go in the middle, something along the lines of the Northwest MLS rule that's been in place now for about a year, and the one that was proposed to be adopted by MLS PIN in the settlement in that NOSLEC case out in Boston. And that would be that there cannot be a unilateral offer or compensation from listing brokers, but an MLS can have an offer of compensation from the seller directly. So those are kind of the options I think that are in front of the court with regard to the injunction at this point.
I know there's been a lot of questions of, this is a Missouri case. It only dealt with Missouri law. It only dealt with, activities that occurred across 4 MLS areas in Missouri. Why should I in California care? Obviously, the judge could, prohibit NAR from doing that, in Missouri, or he could prohibit them from doing it nationwide, couldn't he? And what has the Department of Justice been rattling about with all of this?
Yeah, those are some good questions and observations. So something that kind of was interesting right at the beginning of the trial, the case included Missouri-specific statutes and violations, and the plaintiff voluntarily dropped those before the trial began. So what proceeded in Missouri was a federal-only case. So the court has some latitude here. He has some discretion on how wide he can cast this net. Could he order NAR to issue a rule specifically for Missouri? Yes, he can do that. I think there's an argument that could be made that he can even go as broad as making the rule required for the whole country. So the judge has discretion. We don't know what's going to happen. There are still some things to be determined, but it could be Missouri specific or it could be across the country. But let's be honest, the industry just lost a $1.8 billion lawsuit, right? Who's super comfortable keeping the compensation model the way it is moving forward if a judge says it should be changed, right? So NAR has some real practical concerns to consider here in protecting their membership from future claims. Another good aspect you brought up there, Art, is the Department of Justice. And we know that the Department of Justice has been involved in investigating NAR and the specific commission rule. There is a current court order that says the DOJ should not be continuing that investigation because NAR and the DOJ settled. But make no mistakes, it is abundantly clear. We know this directly from the plaintiff's attorney himself. He has fully admitted that he has been in contact with members of the Department of Justice. And it's pretty certain now that what the Department of Justice wants is no offer of compensation in the MLS. And we know that because in that no-select case in MLS PIN, they objected. They asked the court to push the hearing back a couple of months, specifically so the DOJ can interject an objection on the MLS PIN rule, which was that middle rule where the seller is going to make an offer of compensation to the MLS. And we are anticipating the DOJ is going to say that's not good enough. We need a complete elimination. So I anticipate, and we kind of think that's the way that the plaintiff in this case will be leaning when the plaintiff brings his motion for the injunction in front of this judge here in the Sitzer case.
So just to put some things in context, I started in my position in 2005, and I remember very specific discussions that were occurring with the Department of Justice around the IDX. They were changing the policy at that point from an IDX. Well, what became the IDX policy was originally the IDL policy, and the Department of Justice had sued NAR. There was a consent decree that came out that gave us the VAL policy, gave us IDX, but the Department of Justice was rattling pretty hard at that time for commissions to be taken out of the multiple listing service. So it's not a new concept, and it's not something that the Department of Justice hasn't posited before to the National Association of Realtors. Obviously, when we're going out and speaking, Ed, we're getting a bunch of different questions. And, it's been my position that the multiple listing service is the biggest gift that the brokerage and agent community has given to the consumer. And, some paths forward, are things that we're looking for. CRMLS has been, strategically planning for some of these things since the lawsuits initially were put out there. I'd gone out on a limb that I was very dubious that a 6-person jury made up of people that had never bought a home before and had never been involved in that process was ever going to deal positively with with what they were going to be presented in a court of law. So as we move forward, Ed, let's talk a little bit about what that concept of an MLS without compensation, looks like. Obviously, this is not to be popular with some people, but this idea of buyer agency and how you procure agreements with your buyers is going to be pretty big as we move forward. So let's talk a little bit about buyer agency, listing agency, listing agents and what they're doing, potential, changes to concession fields. Buyer agency agreements have been around forever. They're in the California marketplace, not utilized as much as we'd like to see. Where do you see that going with buyer representation agreements?
Yeah, so first of all, I think I like to start from the very beginning to say that buyer agency is alive and well. Like you, Art, I started as a realtor in 2002, and I remember reading in my first year of being a realtor that 82% of buyers used a realtor. And I was around as a realtor when we were going through IDX, and I watched the fight. And the doomsdayers run out and say, if we let people put listings on the internet, buyer agency is dead. Nobody will use a buyer's agent ever again. And you know what? In my career, and if you go back in the last 4 or 5 years and pull the numbers, you're going to see that buyers used buyer agents 92 to 95% of the time on transactions. So not only were the doomsdayers wrong, they were absolutely off the mark. And buyer agency actually increased when the consumer got better access to listings. And I think that makes sense. If you've ever been a buyer's agent out in the field, I know in my own practice where I am also a buyer's agent, I spend less than 15 to 20% of my time looking or searching for properties for a client. They can do that themselves without me. My value as a buyer's agent has almost nothing to do with trying to identify a home that happens to be for sale right now. It's about getting them access to the home. It's about talking about what's going on in the community. It's helping them make decisions about what their life is going to be like in this particular neighborhood, in this particular home. Other than who you marry, where you live and the house you live in has a very major impact on a lot of other aspects of your life. And people don't want to make those kind of life-altering decisions by themselves without expertise. The California RPA, I believe, is 18 pages now. Who's going to walk you through that without buyer agency?
Ed, one of my favorite sayings is a person with an experience is never at the mercy of a person with an argument. And you have a unique background in that you've had that experience in being a real estate agent before you went to the dark side and started practicing law. Tell me a little bit about that experience, especially in the commercial side, where you have that experience of where there's no offers of compensation primarily in a multiple listing service, and how that successfully operated with buyer agency.
Yeah, so I've lived this
agency, I guess you would say.
Yeah, definitely. I mean, I've lived this experience being I got my CCI back in 2006, where I represented, did a lot of commercial work. I've closed over 250 commercial transactions. None of those were on a multiple listing service, and none of them had any kind of offer of compensation coming from the listing broker, by rule or MLS. There is no MLS in commercial. It's a free for all. Frankly, it's a horrible searching experience because there's no MLS. But from a transactional point, what you're required to do in commercial is have a buyer representation agreement with your buyer before you start showing properties. That's a must. And then when we go to make an offer on a commercial transaction, what we do is part of the offer includes the buyer agent's fee, and it's part of what the buyer is asking the seller to pay. And if there's any negotiation that goes on about that fee, then as the buyer, we adjust the sales price to accommodate that fee. I can tell you, I have been paid on every situation where I've represented a buyer in a commercial transaction, and more than 95% of the time, I got all of my money directly from the seller inside of the transaction. It shows up on the seller side of the closing statement, just like it does in residential. It's just part of the negotiation of the contract. And so the fact is, buyer agents will get paid. Buyer agents will get that financed by the lender. That is all still in play. Do we need to do some tweaks with some contracts? Do we need to educate agents to be comfortable in the residential space of doing it this way? Absolutely. Could we get a little bit of assistance on the lending side to help clarify what is an acceptable concession for a seller to pay? Absolutely. So there's still work to be done. But most certainly the importance and critical nature of buyer agency will be alive and well in a world where there's no compensation in the MLS.
So to the benefit of realtors in California, especially the California Association of Realtors in December last year did include some new forms into ZIP forms. Obviously, there's a brand new iteration of buyer broker representation agreements that comes with a number of different flavors that people can choose what they're comfortable with. Obviously, buyers agents are going to start having to have those conversations a little bit more intently with buyers on the compensation piece. But there is a secondary form that CAR did put out called the SPBB, which is the seller payment to buyer's broker. Obviously, that may need to be tweaked depending on what the judge comes back with. But let's talk about that a little bit. This process of the forms already being there, and it's being noted on the RPA, and it's an additional form for people to fill out in order for compensation to occur.
Yeah, CAR and the members of the forms committee did a really smart, forward-thinking thing when they gave us that form. There was an anticipation, maybe, hey, if things don't go our way, it's important to have a mechanism to do exactly what I explained. And what that form allows you to do is when you do and you complete the RPA, there's a section of the residential purchase agreement where you can check a box, and it makes reference to this form, right? The seller's payment of buyer's broker. Now, what's interesting is the very first sentence of that form says, buyer's broker has a written agreement with the buyer where buyers agree to pay a certain amount of money, right? So buyer representation agreements are absolutely mandatory for using this form. And what this form allows you to do is it provides an opportunity for the buyer as part of the offer to request that the seller pay for some or even all of the buyer broker's fee. And so that way, the amount of money that the buyer is going to pay the buyer's broker is included in the purchase price. By the way, this is exactly what happens under the current system that we've had for decades, right? The buyer broker fee has always been part of the purchase price. It's always been something that the buyer has paid as part of the price he's paying for the property, right? And so there's really no additional risk to the lending community by doing it this way. And there's some recognition of that in some of the concessions that are permitted under existing rules. And so the use of that form can immediately be used if the judge comes in and does something super quick. But I also agree with you, Art, that there's some additional tweaking that could help. I think one of the things that will need to happen is the listing agreement is also going to need to be modified. Right now, there's a whole half page of the listing agreement that talks about the MLS being sharing compensation, and that in the listing agreement, there's a place where the listing broker and the seller agree on what number, what amount of money should go to the buyer's agent and be offered in the MLS. Well, that whole section, depending on what the judge does, may have to come out of the listing agreement. I would suggest that it won't just come out, it will be replaced. And what it will be replaced with is some kind of an advisory that lets the seller know, and this is something that good listing agents are also going to have to do, is walk your sellers through the fact that, hey, if you've got an entry-level property, maybe a first-time move-up buyer type property, the kind of property that has VA loans, FHA loans, conventional with 5% down or 10% down, where the buyer is likely to need all of their resources and money simply to qualify and get a down payment in. Hey, seller, if you want to open the availability of this property to as many buyers as possible to buy it, you need to be ready to step up and contribute to and participate in the payment of that buyer agent's fee. Again, when you look at comps today, that number is already in the MLS under a sold listing, under a sold comp. So you're not giving any additional money away by doing that. This is the kind of conversation that the listing brokerage community is going to have with their sellers to prep the seller to receive the SB or SPBB form, and have the parties understand that now the compensation going to the buyer's agent is going to be an aspect of a negotiation, which is exactly what the Department of Justice and these consumer attorneys want. They want the buyer and the seller themselves to be directly involved in the process of negotiating and setting the amount of compensation that is being paid to the agents.
So obviously, the MLS will change to a certain extent. Do you see, some additional fields being added in, some additional requirements when it came to concessions and the amount of commissions being paid?
Absolutely. At CRMLS, we already have a concessions box, nice big box. So when you report your sale to go to a closed status, we ask you to confirm prices and dates, and then we ask you to give us the concessions. Now, historically, right now, we don't have really any rules around that. It's not a mandatory field to complete. And again, in CRMLS's and Art, under your leadership, right, the anticipation of planning for contingencies, we've asked our rules committee a couple months ago to go back to their local associations, back to their brokerage and offices, and ask agents, what do you guys want to see as far as rules surrounding those concession fields, right? I want to know, as a compliance officer in the MLS, what amount of money of a concession should trigger that you should have to put something in that field. Do we break the field out into some pieces? So, we want to see concessions with regard to repairs. What about buy down on loan points, which is super important right now, and that's happening. And now, if we need to, we could capture how much of the seller pay of a buyer's fee, as this is important information for appraisers to accurately reflect and appraise the value of a property as to what a seller actually got out of a transaction, as well as our agents and brokers who are doing CMAs and making recommendations and giving consulting services to buyers and sellers to have great, accurate information. So we as the MLS are very well positioned. We're very prepared to be able to accommodate this change and then be able to make sure we have that high level of transparency and a high level of accuracy. Because what we're going to be able to do as a compliance department is we're going to be able to call up and ask you to provide us the closing statement to confirm that you've accurately reported that. So that is certainly something that we'll be able to, as a compliance department, make sure is accurate for your guys' use in giving good advice to clients.
Obviously, Ed, there's a ton of questions in regards to how this is going to operate. Obviously, I wish I could give brokers and agents definitive answers right now, how everything is going to occur. Obviously, what we're hearing out of a lot of different, talking heads is that this is going to take years to, filter down. Obviously, our biggest concern at the CRMLS level is, given the level of agitation that the Department of Justice has right now in, the process of more closely regulating real estate, we just don't think that is going to hold true, that it's going to take years. And we're counting in months before some of these changes could come to fruition. Obviously, another one of my favorite sayings is by Wayne Gretzky, is some people skate to where the puck is, I skate to where the puck's going to be. We're trying as much as we possibly can to skate to, where those battles are going to be in the future. And I'm a big believer in contingency planning, and our board of directors has done an incredible job of strategically trying to figure out how all of this stuff is going to work out. So we feel at the CRMLS level, we're in a great place for some of these issues. Obviously, there are, more questions than we have answers at this point, but I think what Ed and I have done here today can give you guys a very clear idea of what we see coming and the speed of which that may be coming down. Obviously, CRMLS is going to remain committed to doing everything we possibly can to educate our members on the value of the multiple listing service. One of the things that I've always pointed out is that I don't believe that the residential consumer is going to accept a fragmented database. And everything that I've been doing and this board of directors of CRMLS has been doing over the last 15 years has really been focused on putting brokers and agents into a very strong position of having the access to the most up to date and encompassing pieces of data that we possibly can. Everything that we've been doing for the last 2 years and aggregating data and pushing pieces out to the membership has been, really focused on giving you guys as much as we possibly can. So I think we're in a great place. I think that, we will do everything we possibly can, once these judgments do come down, that we, put you as brokers and agents and members of CRMLS into the best place that we possibly can. Do you have any closing statements, Ed, before we shove off?
Yeah, I think the only thing I want to say in closing is, while this may surprise some of you, it's okay. The industry is always facing constant change. We lost the sub-agency concepts. We went to the, people using internets, and again, the naysayers, the doomsdayers were in each of those situations were completely wrong. And I think I want to be encouraging at this point that as buyer's agents, there's some great opportunity here. The ability to modify how you charge. Maybe I charge, based on how many doors I open. And the freedom of negotiating what the needs are of your specific consumer now are more of a reality under this system than they've ever been before. So as you look at this change, don't be fearful of it. Don't think it's going to end a career, but embrace the opportunity that it's going to present to you to be a great agent to go take care of those consumers. And we as the MLS are going to be there to support you and those consumers to our fullest.
I think that's a great point, Ed. One of the things I statistically look at is the age or the length of time that people that subscribe for services to CRMLS have been in business. Over 55% of you have never even seen a down market until we started going through what we've been going through for the last 8-9 months. So recognize that if there has been any constant in real estate, it's been the constant of change. And the way that you've been paid, it's not always been this way. And there are avenues forward. And our biggest message to you is relax. We'll get to the other side of this. This is not an extinction level event for real estate or the practice of real estate. And we look forward to assisting you in any way that we possibly can to make as much of this as clear as we possibly can. So with that, Ed, thank you. It's been a pleasure. And hopefully we'll do a little bit more of these as time goes on.